Welcome, everybody. We are so happy to have you here on Zoom and LinkedIn. Today, we're going to be talking about HIPAA Security 2.0, what to expect from the impending update. And I'm so happy to have with us, you're going to hear OrbitalFire Cybersecurity CEO Reg Harnish and healthcare compliance attorney and shareholder at O'Connell and Aronowitz, Kurt Bratten. And these two, you may have seen some of webinars they've done before. They're always filled with a ton of information that you can take back and start using today. And today they're going to break down what the new HIPAA security rule actually requires, what it means for the relationships between covered entities and their vendors, and what both sides should be doing right now before the compliance clock starts. I know we're going to start off talking a little bit about that timing piece. With that, Reg, you want to start everybody off?
Sure, fantastic. Thank you, Dana and Kurt. So great to see you. I think the last time I saw you was at the dance-a-thon. Is that your memory?
Oh yeah, yeah, definitely. I'm a huge dancer.
Perfect. Well, let's dance. I know we've got some breaking news. You want to kick this off for us?
Yeah, in sort of classic style, the federal government here has, just prior to this webinar, has issued a very brief notice. It actually doesn't even come from HHS. It comes from the Office of Management and Budget. And what it says is, despite the prior projections about when this HIPAA, these new modifications to the HIPAA regulations would become final, um, they are going to push it back a year. And so this very notice, which lacks even an explanation as to the reason why, um, it tells us that it is now July 2027 when the federal government suggests that this rule will become final. Now, I want to emphasize even that notice is not binding on the government, but this is their effort to advise everyone, the industry, when this rule is likely to, be finalized. So we have a little more of a reprieve, but today we'll talk about the pros and cons of waiting.
Yeah. Yeah, and in my opinion, an unvetted opinion for sure, but I think when you wait long enough, the changes become so monumental that you're likely to get resistance. I think the second part of that, if there is a why, is that enforcement of the HIPAA security rule or HIPAA in general, I think has been a little bit dodgy at best. And to go from an antique, the original HIPAA security rule, which really hasn't undergone any material update for almost 2 decades. When you go from an antique that lacked enforcement and clarification over time to something brand new, you're likely to get a lot of. So the question period for the HIPAA security rule was one of the things that dragged out super long. And then I think they just got to a point where it's like, there's no way we're going to resolve all of these questions, concerns, and issues by May of 2026, which was their original anticipated timeline. So what does it mean? For us as an operator in the HIPAA space, building cybersecurity programs, building HIPAA compliance programs, managing these things for our customers, we see a couple of things there. I think there are pros and cons to this. Obviously, the first doesn't need any explanation. Having an additional year or so to prepare for some pending enforcement, always a good thing, right? We get to, even for organizations who are mature, they get time to polish, mature, evolve those controls and those programs in a way that makes them more prepared, more responsible, and more compliant. But let's not forget that there is a mountain of changes that are coming through, and we're going to take you through the ones that we think are, most meaningful to our customers today. But it also gives OCR and others time to, have their opinion included. And so who knows what will change? There's been some speculation over the last 6 months about where OCR was going to land in this update. And now they've got another year to review, revise, and change that. So everything that we've learned up to this point is subject to change. So we think that that is a con. We were sort of settling in on a few things. And of course, most of my customers are, pursuing HIPAA compliance, but we're not really just there yet. And so we just went from being late to being on time. So I think if we look at this in its most raw form, it's probably good for most of our customers, most covered entities and business associates in general. And hopefully the additional time gives OCR the opportunity to really think through these changes, how they'll affect the healthcare community, and what is required truly to meet the objective of this thing, which was protecting patient and health information. So, as I mentioned, this is really we're going on 2 decades now. By the time we get around to July 27, it'll be very close to that. And other than the omnibus, which really did nothing other than organize a few things and introduce some requirements around breach notification, there have been no changes. There has been some clarification. And so if you're plugged into OCR and the HIPAA designers enough, if you're close enough to them, there have been interpretations on controls that have been released. So we've been following those. But again, even with those, nothing super meaningful. They have definitely made it clear that the update will not just apply to covered entities, so think hospitals and clinics, but rather anyone who's in that supply chain. I believe that due to the success of other federal programs, federal enforcement of cybersecurity programs, that HHS and OCR are going to start adopting some of the things that have been successful in the DoD supply chain. And I'll just mention this because I think it is important, is that enforcement in HIPAA has been dodgy. Most of the organizations that come to us really maybe just be starting out, even though the regulation and the law has been around for a very long time. But something that happened differently with the federal government and enforcement of a cybersecurity standard is something called CMMC. And this, you don't need to remember this, it's probably the first time you're hearing of it. But for suppliers who are in the DoD, the Department of Defense supply chain, years ago, a cybersecurity standard was introduced and enforcement has been incredible. And that's because the Fed said, we're going to design the program, but we're not going to enforce it. But instead, the people that we rely on the most, the top 10, what they called primes, contractors, Boeing, Raytheon, General Dynamics, Lockheed Martin, et cetera, we are not going to pay you a single dime until you can enforce and prove to us that your entire supply chain is also compliant. So what's happened is, because this has been a very capitalistic approach, is that there's been a lot of movement. All of our customers, it's probably the fastest growing part of our business, are now scrambling to do these things. I think what we're going to see in July of 2027, if that's the date, is HHS and OCR saying we're doing the same thing, and pushing enforcement down to the supply chain, which is much more likely to be successful. Now, again, I credit them for finally doing this. It probably is overdue by about 10 years or more. But the world has really changed, and everything from AI to the cloud and mobility, the technology and capabilities at the clinical level, roll-ups and private equity in healthcare. There are so many things that are different than how things looked back in 2003, that we have almost expired the HIPAA security rule in some ways. So I think that's important. Okay, enough of a backstory. Let's get into the proposed changes. Again, we now have a year of speculation, a new year of speculation. So some of these may change, and we will be back in touch with you on all of this. But let me just start with risk analysis and risk management. Probably my favorite thing. It's the whole reason that cybersecurity exists, is to manage risk to important assets. What is changing, what is alleged to be changing, is that prior to the update, the real focus, the real emphasis, and the first question that every questionnaire had is, did you do a standards-based risk analysis? They call it risk analysis in healthcare. Everyone else calls it a risk assessment, but a risk analysis. Did you do a standards-based risk analysis? And that risk analysis was based on NIST and a few other supplemental standards like NIST 36, NIST 66. They really relied on NIST very heavily for this. It's a 9-step process, but essentially it starts with identifying your ePHI, creating the scope, defining the scope, conducting controls evaluations against the HIPAA Security Rule, identifying, documenting the findings and recommendations, and then building out a plan. Now, what's happened is that, and this guidance was released really about 3 months ago, so it's very recent, is that is no longer compliant. And OCR is now saying that's not what we really meant by the risk analysis. What we meant by the risk analysis was continuous risk analysis. And so whether there are changes to your ePHI asset inventory, changes to your organization, really anything that could introduce or change your risk profile, you're now due to perform another risk analysis. And this concept of risk management is what we really meant, which is not only is it continuous, but you have to show the rest of the steps. So conducting the risk analysis essentially provides a roadmap for you. It identifies the risks to ePHI assets, and it tells you what you should do about it. But that's where it stops. That's where the risk analysis stops. Risk management picks up and says, okay, that roadmap, we want to see assignment, we want to see accountability, we want to see progress, we want to see continuous improvement over time. And so they've moved away from risk analysis and these point-in-time efforts to the process of a continuous risk management function. That is a big deal because it's one thing to perform a great risk analysis. It's another thing entirely to demonstrate continuous improvement, over time. The next thing is that prior to the update, it was easy enough to just conduct an interview or maybe take a quick look at a few documents and score those according to the established rubric for the HIPAA Security Rule. But now the emphasis is going to be on auditable evidence, meaning if we say, or we ask our customer, hey, do you have an access control policy? It means that we're also going to have to collect that and submit that as evidence to support the score that we provide. And generally speaking, that's called an audit. Now, assessments are easier because you're not typically collecting auditable evidence. And so there's less work to do, takes less time, and it's a little more subjective. With the introduction of auditable evidence for every control, those risk analyses will take longer, they will be more complex, harder to do well, and more expensive. And then last, again, having a plan is no longer sufficient. You're going to need to show that you took the risk analyses, you created a roadmap, and you held your organization accountable for remediating those issues. You're going to need to demonstrate with a plan, with the outcomes of your risk analysis, with the evidence to suggest that you've implemented or evolved controls, whatever is required, you're going to need all of that documentation. So the audit trail, auditable evidence, and risk management from our perspective are the big changes because it really does evolve and create some complexities around the process of managing risk to ePHI assets.
Yeah, and Reg, just as a sort of a point of emphasis here, before we talk about the addressable issue, right? Risk management, risk analyses. I've been involved in dozens of OCR investigations when they begin to investigate a breach or an incident or a report. And I have yet to see a single investigation in which the very first request is not, give us your documented risk analyses or assessments, right? I mean, this is number one on the priority list for the federal regulator that monitors this area, and it always will be. And to be clear, you could have a breach that has absolutely nothing to do with your risk assessment, right? The breach often has nothing to do technically with the risk assessment, but they want to know for every single entity that they investigate whether you are conducting risk assessments and conducting risk management. And so, this will remain. If you're, working on a priority list here for your organization, this should always be number one.
Yeah. And one last point, if you go to the OCR Wall of Shame, I'm sure everyone has the link bookmarked, but essentially the public listing of all declared or verified investigations and enforcement actions. And if you look into what OCR found when they get into their investigation, the very first thing that they note in every single one of these enforcement actions is that the organization did not perform an effective risk analysis. Their deduction is that if they had, that this breach or the likelihood of this breach or the impact would have been significantly less.
Yeah. So now we're going to talk about these addressable controls. This is one of the major changes that was contained in the proposed rule. And as Reg correctly points out, it's HHS they may modify things in some ways, but I will tell you this is a theme that I saw throughout the proposed rule, and I do not see this changing. And it's really the removal of much of the flexibility that the prior HIPAA regulations contained, right? The addressable standards, for just as sort of a refresher here real quick, right? These were certain standards and controls that were designated in the regs as things that you could kind of review and come up with your own plan to address. And you could come up with alternatives based on your organization, its size, its budget, things like that. You were allowed to do an analysis, in essence. You were supposed to document it, but you didn't have to necessarily implement the control, provided that you could come up with a sufficient justification or alternative. So in this proposed rule, OCR is removing those addressable components. They're making them all required, and that includes one of the biggies, which is encryption. Right? Encryption, when we talk about encrypting ePHI at rest and in motion, now it's got to be encrypted, and you don't have that addressable or flexible standard to fall back on. And so I think for a lot of organizations, this is going to be a significant shift because, right, organizations they utilized that flexibility. I can't think of a safeguard, even putting aside the legal standards. I can't think of a HIPAA safeguard where I've seen clients implement sort of a wider variety, right, of compliance safeguards. I mean, people do a lot of different things in order to meet or partially meet the encryption standard. But I'm unfortunately here to tell you, I think that is going away as of next summer. And so this is a significant, and it's an organizational standard that you've really got to pay close attention to because, right, how your people properly encrypt things, especially those organizations that rely on those sort of, whether it's the click of a button or these sort of optional encryption technologies as a way to send emails that are ordinarily not encrypted, but you've got to encrypt the ones that contain PHI. I mean, we're now into a standard where I'm not sure that sort of an approach is gonna work at all.
Yeah. And the concept of compensating controls is what we call it in cybersecurity. That is so central and so important for smaller covered entities in organizations because the implementing a control, word for word as it's prescribed can be difficult at times. And so our hope is that, okay, sure, I think when they defined addressable versus required, they left a little too much wiggle room. I think anyone could argue that. But I do hope that they clarify what this means and also allow compensating controls that are documented, verified, retested, right? They're not permanent, et cetera. Because compensating controls that's part of managing risk well. And so we hope that they rethink this a little bit.
Yeah.
Now, I mentioned business associates. It has become very clear. Anyone who's got a TV or a newspaper or is paying attention, realizes that many of your most critical risks are going to come from places outside your organization. And when that happens, the disruption can be massive. And there's no better example than Change Healthcare, where dozens of my customers either weren't getting paid or they couldn't bill themselves because of the disruption at Change Healthcare. It set a whole bunch of new precedents. And I think what HHS and OCR are trying to design into compliance is a recognition that every organization subcontracts or outsources or uses cloud applications, software as a service, and increasingly so. And so because of that, defining your scope, which includes, a third-party billing entity, is going to be really front and center on this whole thing. So they're enforcing these things through business associates because that's the accepted terminology. But the reality is that in defining your ePHI scope, we have to do a much bigger and better job of figuring out where is it, where does it go, who has access to it, and then we have to broaden our scope of our risk analysis in the risk management function to include all of those sort of first concentric circle third parties, business associates. They come in a lot of different shapes. Your MSP is probably one of your biggest risks today. Your billing provider, people who are doing marketing and communications for you or outreach. There are so many places where ePHI may be exposed that are not under your direct control. And so not only are they making it clear that business associates are not in scope, but they're now forcing you as part of the expanded risk management function to do third-party risk management, right? That is a significant component. But there are a few specifics in here that we find a little bit alarming. So enforcing or forcing a business associate, a third party, to notify a covered entity of any kind of material event within 24 hours, that can start to be a problem. I mean, there is so much crime. There are so many errors there. So if you have to spend time notifying a covered entity every time something happens, you're going to spend a lot of time doing that. So only because I've personally responded to hundreds and hundreds of incidents, and I know exactly how long it can take before you have any meaningful, useful information in the event of forget about a breach, just any kind of cyber events, that this 24 hours may backfire. So this is one more area that we hope that there is some interpretation and some flexibility around how that's enforced. And then you can expect that your business associate agreement template is going to require some refactoring, just because the concept of third-party risk management is going to need to be stitched in there. We're going to come back to accountability, but no longer will it be acceptable for you to just do casual due diligence on a billing provider. You're going to need to send them a questionnaire, or you're going to need to collect validated attestations on their HIPAA compliance. And you're going to need to review it and score it, and then determine if that third party, that business associate, is an acceptable partner. That's all part of the third party risk management process. You're going to need to do that. And you're also going to need to show auditable evidence that you did it. So what was the score? What did you do about it if it didn't meet your minimum standard? These are all things that are going to be enforced, because the reality is your orbit, no pun intended, I guess pun intended, but your orbit is no longer, a server in a closet in your office. It's, it goes much more, it's much broader than that. And the risks can come from those places as well.
Yeah, and just quick tag along. I mean, the reality is you're all going to have to be, you're going to have to take on a different role here as kind of the bouncer, right? Everybody doesn't get into the party anymore. I mean, being able to provide a good service is not enough. They're going to need to have security. They're going to need to be able to demonstrate that they can manage their own risk, because think about the damage that like a Change Healthcare did to so many healthcare providers. I mean, if you're out there squirming in your chair right now, but I mean, it's devastating when one of your business partners absolutely fails and you are completely hung up. For example, incapable of billing, incapable of bringing in money. I mean, it's devastating.
Yeah. Well, I just thank you for that. I'm going to submit a request that we change this to bouncer associates.
Yeah, there you go. All right, so contingency planning. This is another big one. Um, if you look at the third bullet down here, I'll start there, right? The proposed rule contains a requirement that everybody have a business continuity plan that is capable of restoring or recovering ePHI in 72 hours. Now, even if HHS modifies that standard, maybe they tack on a few hours, give everyone a little more time. The reality is, I think that contingency planning is coming in the final rule, and I think there's going to be a hard requirement around this notion that you've got to have a plan that must get you back up and running. And one of the reasons I say that is because there are other requirements that are tied to that. One of them being when you implement your contingency plan as a business associate, you have to notify your covered entities, right? So I mean, you want to talk about sounding the alarm, right? Imagine if Change Healthcare had to notify what? Maybe a quarter of the healthcare providers in the country that their contingency plan had been implemented. I mean, on some level, it can create a panic. It can cause government intervention prior to any breach report. I mean, we're talking about some pretty significant requirements here when you just think about those two things. And I'll also say when it comes to backups and contingency planning, well, I think that the ransomware sort of epidemic has caused a lot of organizations to get better at handling backups. I still think this is an area of weakness overall, and it's something that you're really going to have to focus on. Again, if you're looking at a prior or you're creating a priority list, I think this has got to be up near the top.
Yeah, and they're using mature terms like the business impact analysis. For me, not only does it sort of register as a refocusing on the things that are truly important, particularly for smaller organizations, but this is a mature methodology. Conducting a business impact analysis requires you to really understand, hey, what services do we provide to our customers or patients or constituents? And to deliver those successfully, what things do I need in place? And if there is a disruption, what are my recovery time objectives and recovery point objectives? Like they're using mature terms in a way that suggests that they got educated on what contingency planning really should look like. So the good news is that complying with this actually creates an asset for your business, including testing, right? So whether it's incident response or business continuity, contingency planning, or tabletopping, however you do these tests, wouldn't it be nice to have the confidence that your organization has practiced responding to ransomware or a critical third party like Change Healthcare just disappearing for months? Like, wouldn't it be nice to have the confidence to do that? So they're using a lot of the right terms. Clearly, they're getting a little bit nerdy about this, but there's some stringent additional requirements. And I will tell you that tabletops are one of the most impactful things that we do for customers because they get to actually practice. It's not a document that you download a Google template, do a find and replace and then throw it on a shelf and then eventually someday dust it off when someone asks for it. This is something that is part of your culture, part of your operational standard, where you have built a capability around response. Again, whether it's wire fraud or a fire in the cafeteria. So these things are all good for everyone. And by the way, wouldn't it be nice if you had the confidence that your third parties were effective contingency responders and incident responders? Right. Having that kind of confidence in your supply chain means everyone has less risk. So again, it's kind of lumped everyone together, this idea of managing risk. It is a community effort. And this is one place where I think they have gotten it right. Yeah. Now, the first step in a lot of risk management functions is understanding what are the crown jewels, like what is worth protecting How do we protect it? What are the vulnerabilities that are exploitable today? What remediations, what mitigation is in place or possible? So that all starts with knowing what you have. Today, a simple spreadsheet is perfectly fine. But today, because your ePHI probably lives in one or maybe a dozen cloud providers, you may be sharing it with a number of your third parties in your supply chain. Organizations may be taking custody of it, they may have access to it. And so understanding what your ePHI asset inventory looks like is the very first step in conducting a risk analysis. We got to know what we have first. So the asset inventory has to mature. We have to identify things like, where is it? What kind of asset is this? Classify it. Who is the owner? Maybe even more importantly, who's the custodian? Because oftentimes your IT provider may have it, or a hospital may have your data. And so by maturing our asset inventory, from everything from incident response to risk analysis becomes easier. Additionally, they're most likely to request some kind of data flow diagram, which is a visual picture of your inventory. So if you think about the third parties, the partners, the suppliers that you have in your supply chain, or maybe you're a more complex organization and have multiple locations or legal entities, like not only what does that list look like, but where is it created, stored, processed, transmitted? All of that is going to be important. The data flow diagram is part of that auditable evidence that we will look at during a risk analysis. And then, of course, enriching, as I mentioned, the inventory with other attributes. It won't be enough to just have a list of, I'm using Azure or Dropbox or Outlook. That's not going to be enough. We're going to need to enrich that inventory so that it's meaningful and that the asset inventory itself can contribute to our success in all of these other areas, not just defining scope, but from business contingencies to, hey, what assets, what computers do we need to scan for vulnerabilities on a monthly basis? All of that needs to be driven off your asset inventory. So what you can expect is during a risk analysis, we're going to spend more time upfront really honing in and accurately defining what is the scope of this thing we call our ePHI and attributing that out. So all of that can be super helpful.
All right. Another significant addition in the proposed rule is this notion of accountability, and specifically personal accountability. If you are familiar with New York's Department of Financial Services cybersecurity program, they have an annual certification that has to be made by one of the organization's officers, and it requires a degree of personal accountability and, at least theoretically, if not practically, personal liability, to the extent that there is a false certification. It looks as though HHS has considered adopting something similar here for HIPAA. And so they're looking at implementing a personal sign-off by some kind of a senior official. I mean, I assume we have some security officers on the webinar here today. So, you're going to have to start thinking about stuff like this in the future, because it's something that, right, the way it should be approached is it's not just signing the piece of paper, it's doing the work that would allow you to feel confident signing the piece of paper. And, I think that type of outlook is what the government is looking at as a trigger or a lever to try to force organizations and the people who lead them to implement, appropriate safeguards and plans here. And one of the themes that Reg and I keep touching on here, and you can see it right in the rules, is that this notion of documentation, this notion of having artifacts and hard assets or materials as a way of proving that you are doing the things that you say you're doing. This is another significant change. I mean, you know, prior to this rule, I mean, having policies was a big deal. And again, I think back on a lot of the OCR investigations. Oftentimes, I could answer their questions by providing a policy and then explaining how that policy was used and followed and giving examples of how the policy was followed in the context of whatever the incident is that's being investigated. Um, I think those days are soon to be behind us because now they want documentation for really follow through on all of these things, and that is I mean that is ultimately what accountability is, right? You know, we've got this saying I often hear and sometimes repeat in New York about if it's not documented, it wasn't done. I mean that is how a lot of New York State agencies view it, and it appears as though the federal government is headed in that direction. Um, Another form of accountability is having business associates attest to compliance with their covered entities on an annual basis. And so, again, we talk about, I use the bouncer analogy. Well, bouncer, cop, however you want to look at it. But now you might have to be chasing your business associates around to make sure that they're giving you that certification on an annual basis. Because if they can't even do that, then it's got to raise questions about what they're doing on the other hard requirements, right? If you envision a world in which this is the standard and you're not getting those certifications, then I think that's a clear sign you've got bigger problems. And so again, this process of analyzing and genuinely considering, truly considering, you know, who you're partners with. It's something that, I mean, right? Like accountability and signing a certification. It in the grand scheme of things, this will not require the act of signing something will not require a significant change. But what it's supposed to do is it's supposed to require a significant culture change, right? It's supposed to require that the people who've got to consider this and sign these certifications are going to say, wow, right? I have not had to put my name on the line before. And now that I do, I'm going to look at this a little differently.
Yeah, and I'll mention, just because it's relevant, something that has popped up in the DoD supply chain space around CMMC. Again, not meaningful to this conversation, but some of the concepts are. One of the things that has come up repeatedly is a federal law that was enacted in 1863, if my memory serves, somewhere in the 1800s. It was called the False Claims Act. And essentially, the major suppliers and the primes in that supply chain have said and have stated and called on this False Claims Act as part of the, hey, listen, this is a federal law. Telling the truth on these things is federal law. I only bring that up because I do think that there is likely to be some kind of formal attestation or certification on an annual basis as to what your compliance status is. It doesn't mean that you have to be compliant. In fact, with New York State DFS, you are given the option of as certifying as either compliant or non-compliant, but with a plan to be compliant, right? So it's not going to require 100% compliance immediately. But between the annual attestation process and this rebirth of the False Claims Act, I think enforcement is going to take on a totally new tone when we see this. I feel that, and certainly in our industry, that the HIPAA security rule is a punching bag. It's like the poster child for how not to enforce something that you want to happen. And so I do think now that they're coming around again and that they've got another shot at the apple, they're going to take enforcement more seriously.
Yeah, and Reg, to that point, with the False Claims Act, I mean, there is precedent where the federal government has looked at the certification that Medicare and at times Medicaid providers have to give, which essentially says, I comply with the law. It's like a certification that every provider has to make. There is precedent for the federal government looking at that and saying, You signed a certification saying you're going to comply with the law, and we can find an instance in which you did not, right? Now, think about all of the regulations, right, that providers and organizations have to comply with. I mean, I doubt there's anyone who is in 100% compliance with all of those standards all of the time. So if you think about how this standard could be extrapolated, it is a little scary. But
Well,
I mean, one way to look at it too, and I'll just, after this I'll be quiet. But if you look, one of the key issues here will be what is the actual language in that certification, right? How is that language so broad that there's no wiggle room? Because I'll tell you, the New York State DFS certification, there's some wiggle room in that one. So we're going to hope that the wording that they choose to use for this is something where there is at least a little bit of wiggle room.
yeah, the flip side of that also, though, is if you look through some of the enforcement actions, even just over the last 12 months or so, it is clear that OCR has shown some deference to organizations who probably were doing a lot of the right things, but just had a bad day. And let's face it, there are no guarantees in cybersecurity, and no one is compliant 100% of the time, right? Everything changes. And so it's really a journey and a pursuit. And so I do expect that that will continue, where if you've done a good risk analysis and you've built a mission plan, a roadmap of your remediation, and you're holding people accountable, and you're attesting, and you're telling the truth and doing the work, I do expect that any enforcement actions, the regulatory penalties, et cetera, are definitely going to be dependent on your ability to auditably demonstrate that you've been doing as much of the right thing as possible. I will tell you that we have some customers who came to us because they ended up on a corrective action plan from OCR. They are on the wall of shame. And I will tell you that once you are in that corrective action plan, that's when the real work starts, because now not only do we have to do all the same things that we did before, but now OCR overlooks, reviews, analyzes, and comments on every single thing that we submit to them. And so the enforcement aspects, I think they're making those more difficult, but I do think there will be some deference to organizations who can demonstrate that they've been doing a lot of the right things. Okay, a couple of final thoughts here, and I'll let Kurt start on this, because the numbers really are alarming. If you have not seen the wall of shame, the enforcement actions at OCR, it is pretty eye-opening.
Yeah, and look at the chart here, right? I mean, sometimes these visuals really tell the story. I'll also just highlight that the reason the 2025 bar there is in red is that there is some projection involved in that because we had the government shutdown. But if the numbers had held based on the way in which they were going, that is how the full year would have concluded. But anyway, you cut it. It's a massive uptick in the level and the scope of these enforcement actions. And to me, it signals several things, right? It signals a greater appetite to engage in enforcement activity. It signals that they have most likely brought on new staff. I will tell you, one of the quirky things about OCR is their staff, they also enforce the Civil Rights Act. So they've got people who are on one day looking at violations of the Civil Rights Act, and the next day looking at cybersecurity and HIPAA violations. But that's neither here nor there. My guess is they've shifted a few more of those people into the the HIPAA violation and the HIPAA enforcement action, because I think the answer is simple. When you look at the trend, and when you look in particular at the current Trump administration, there is a real movement toward government actions that crack down on what's perceived as fraud or waste, and that bring in money. And unlike the investigations of Civil Rights Act violations, I think that the HIPAA violations are bringing in a lot of money when they really put the resources into it. This has historically been an agency and a pursuit that generates real money for the federal government. So I don't think this trend is going to reverse itself or flatten. I think this is going to really increase.
And all of this is public information, open source. The link is here. Everyone will have access to the slides. But if you just Google OCR enforcement actions, you should get there pretty easily. And then I'll just mention this. There's this, you may not have heard of this yet, but there's this new thing called AI, little cybersecurity humor, but we have no idea what AI is doing to this, the planning landscape, the thinking at OCR, but also the risks that computers and software and data are introducing to healthcare in general. AI can be very powerful. We know it can be very useful. Obviously, we use it every single day, all day. You may be using it all day as well. But from a protection of ePHI perspective, all of us have concerns. We may be overwhelmed by the number of new places where ePHI could potentially be exposed without us even knowing. And so, at best, it's going to be a major distraction. I can certainly anticipate that given another year, that OCR starts to stitch in some of the NIST, risk management framework for AI, that there are going to be some AI undertones or maybe more in the future update, because no one really understands the exposure and the additional risk without conducting some kind of risk analysis. And just given the pace and the heat at which AI is expanding, it would be really inconceivable that they wouldn't have some language that addresses AI and its uses specifically. So the merging of the HIPAA Security Rule and then potentially, the HIPAA, protection for ePHI around AI, I could definitely see an amendment or something coming down the pike that speaks specifically to this general category of risks. And so all of this starts to come together. And then lastly, I think time is on our side at this point. While the security rule has been around a long time, the duration has provided some benefits, right? So it hasn't undergone a meaningful change in a very long period of time. What that's allowed us to do as assessors and auditors and operators is to settle in on what does compliance really look like. So now our job is to obviously be prepared, get as close to compliant with the current HIPAA security rule as possible, and then plan for some of these things, many of which are inevitable, and OCR is as much as said so. The other thing I'd mention, and Kurt, maybe you can comment on this, is generally speaking, when we see big sweeping changes, there's typically a grace period for enforcement. So let's say that the new HIPAA Security 2.0 hits the Federal Register in July of 2027. Undoubtedly, there is going to be a period of time, and who knows what that'll be, but there will be a period of time by which OCR says, okay, it's in the register today, you have 6 months, maybe you have 2 years, whatever that is, there's likely to be a grace period for us to understand it, understand what it looks like for us, and then continue with any required, remediation or changes. That's bound to be part of this process. Kurt, do you agree on that?
I agree completely. I mean, that's certainly historically, that's how they've always done it. And our biggest model for that, right, was what happened with the High Tech Act and the way they rolled that out. There was a grace period built in, and there was even one built in beyond what they published. So yeah, I think that will happen, but I also think that's got to be balanced against one of the points you made earlier, and that's that, right, we're already seeing there are signs that OCR is essentially looking at some of these proposed standards when they're entering into at least these corrective action plans with providers. They are, especially on like the risk management side of things, they are definitely looking at some of these new requirements and they're at least assessing it. So I would not be surprised if you saw investigations, even investigations now in 2026, that are asking the organizations that are being investigated whether they comply with some of these new proposed standards. It doesn't mean you're going to get fined if you don't, but it means they're going to keep track of it, right? I mean, I have one client who has had a couple of, they weren't out of compliance. I'll just say they maybe had some close calls when it came to the whole, provision of records, release of records to patients. And I got the old, again, I keep coming back to these cop analogies, and I apologize, but it seems suitable. So I got the old, warning, I catch you again, you're getting a ticket. I was told point blank by an investigator, I've had 3 of these now, buddy, and you get another one. It really almost doesn't matter what it is. There's going to be some kind of a fine and some kind of a corrective action plan. So what I'm saying is, if you pop up and if you probably go on a list and you probably end up on their radar one way or the other. Even if you're not technically going to get fined and you're not technically out of compliance. I mean, they're very serious about this. And I guess the last thing I'll say about time is, look, it felt like an enormous, I mean, high tech was a huge, huge shift. I mean, we really went from no enforcement to some enforcement. So that was a sea change. This is a sea change as well. I mean, some of these requirements are really, I think they're really going to require some real time to implement. So, take advantage. That's all I'm saying. I'm not saying, you need to go rushing for the doors here, but I would not waste the time.
Yeah. My final point is, and again, I don't even like saying things like this because I don't want it to come across as a scare tactic, because I think obviously our customers are here with us because they want to be compliant and they're meaningfully pursuing that. But we all had a little bit of a laugh here internally. So our very first customer who was on an OCR corrective action plan came to us, and naively we thought or just figured, these are probably employees that are just watching the clock. They're just, thinking about what they're going to be doing that weekend. They're playing solitaire at work. It was not the case. We were severely surprised by the attention to details when we submitted the findings for the risk analysis for this customer, going back many years now, or the risk management plan. They went through every word, and we were very surprised that they were paying that much attention to a customer who really didn't have anything of significance, a couple thousand records, like not a big deal in the grand scale of things. So I do think that we'll probably feel a different tenor from OCR in terms of enforcement and the way that they look at the assessment of their general healthcare community. So appreciate all that. Stay tuned. So as we learn more, we will continue to do these. We hope that you found this helpful. And Dana, I will turn it back over to you to see what questions our audience has.
That's great, Reg and Kurt. Thank you so much. And so far, we don't have any questions. Is there anybody here? Here's your chance to ask. And actually, if you come up with questions afterwards, certainly you can reach out to Reg and Kurt, and I know that they would both be more than happy to chat with you. But it looks like you guys have really done a comprehensive job here. And I'll just reinforce one more time what Reg said, that please look out. We're going to be streaming via Zoom and LinkedIn more of these as more information comes out about this HIPAA 2.0, and we'll make sure everybody stays updated. So thanks, everybody. Have a great day.
Thanks, everyone.
Yeah. Thanks.